Law on Banking and Financial Institutions of Cambodia, Prudential Measures and Internal Control. Accounting Obligations and External Auditors' Duties. Money Laundering, Chapter 13, Prudential Measures Internal Control. Article 42. A covered entity shall, under the conditions prescribed by the supervisory authority, abide not only by the monetary policy rules defined in Law NS/RKM/0196/27 of January 26, 1996 on the organization and functioning of the National Bank of Cambodia, but also the management standards aimed at safeguarding its liquidity and solvency vis-à depositors and, more generally, as regards third parties, as well as the equilibrium of its financial structure. In calculating the net worth of a covered entity on which prudential norms are based, the supervisory authority must deduct not only any intangible or worthless asset recorded in the balance sheet, but also any equity participation in a banking or financial institution, as well as credits and loans of whatever nature or maturity granted to shareholders or other commitments to shareholders under regulatory conditions. Article 43. Under conditions prescribed by the supervisory authority, a covered entity must have an internal control system aiming particularly at 1. Verifying that the operations carried out by a covered entity, as well as the organization and internal procedures, comply with the laws and regulations in force, professional and ethical standards and practices, and the policy of the executive body. 2. Verifying that the limits laid down for risks, in particular counterparty, exchange rate, interest rate and other market risks, are strictly observed. 3. Monitoring the quality of accounting and financial information, in particular the arrangements whereby this information is recorded, preserved, made available, and disclosed internally and externally. Chapter 14, Accounting Obligations, External Auditors' Duties. Article 44. The provisions of ordinary commercial law or of the legal statute of non-commercial societies concerning the closing and auditing of accounts as well as certification of annual individual accounts shall apply to a covered entity under the conditions prescribed by the supervisory authority. Article 45. A covered entity shall prepare, publish and if need be consolidate its accounts under the conditions prescribed by the supervisory authority. A covered entity shall also periodically submit to the supervisory authority accounting statements and reports showing evidence of enforcement of legal, regulatory, and prudential requirements. Article 46. No external auditor may audit a covered entity without prior authorization of the supervisory authority. Before certifying the accounting statements, auditors must be satisfied of the fairness and truth of the annual accounting information reflected in the balance sheet and off-balance sheet items, income statement, and appended statements intended for publication or submission to the supervisory authority. Auditors shall inform the court if they notice that a covered entity has violated legal or regulatory provisions, in a manner likely to undermine the public interest. At the close of their audit, auditors shall prepare and submit to the supervisory authority a report summarizing their findings, in particular. 1. Payment of capital. 2. Valuation methods of account balances. 3. Consolidation methods. 4. Financial position of the covered entity. 5. Agreements that may have been concluded, directly or indirectly, during the accounting year, between the covered entity and its shareholders or its directors. The supervisory authority may request from auditors any information about the activity or financial position of a covered entity. Furthermore, the supervisory authority may forward to auditors its remarks or requests for explanations, to which auditors shall reply in writing. Chapter 15, Professional Secrecy. Article 47. No person who participates in any capacity in the administration, direction, management, internal control, or external audit of a covered entity, and no employee of the latter, may provide to any person any confidential information pertaining to statements, facts, acts, figures or the contents of accounting or administrative documents of which he might have become aware through his functions. Any person who fails to observe this obligation of professional secrecy shall be liable to the sanctions laid down in Article 55 of this law. However, the obligation of professional secrecy may not be used as a ground for non-disclosure vis-à-vis the supervisory authority, auditors, provisional administrators, liquidators, or a court dealing with criminal proceedings. Chapter 16, Related Parties. Article 48. Without prejudice to the provisions of Article 42 of this law concerning the calculation of net worth, any credit granted to a related party by a covered entity shall be subject to a regulation issued by the supervisory authority so that the extent of such credit shall be limited and known permanently. Article 49. For the purposes of this law, related parties to a covered entity are defined as follows. 1. Any person holding directly or indirectly at least 10% of the capital or voting rights. 2. Any company of which the covered entity directly or indirectly holds at least 10% of the capital or voting rights. 3. Any individual who participates in the administration, direction, management, or internal control. 4. And the external auditors. Article 50. The supervisory authority may require a covered entity to consider in a same way loans granted to beneficiaries regarded as related parties because of their kinship or their financial links with persons referred to in Article 49 of this law, or beneficiaries who, despite being under the shareholding threshold fixed in Article 49, would have a significant management power owing to a wide dispersion of capital shareholding. Chapter 17, Money Laundering. Article 51. In addition to the specific legal provisions that it must observe regarding money laundering, a covered entity shall take appropriate measures to identify precisely all its customers and, above a threshold to be defined by the supervisory authority, the transactions carried out through them, and shall keep all relevant documentation thereon for at least 10 years. Chapter 18, Disciplinary Sanctions. Article 52. If a covered entity has contravened a provision of the laws or regulations governing its activities, has failed to heed a warning or not complied with an injunction, the supervisory authority may impose one of the following disciplinary sanctions: caution, reprimand, prohibition on the execution of certain operations and any other limitations on the carrying on of business, temporary suspension of one or more of the executives, with or without appointment of a provisional administrator, compulsory resignation of one or more of the executives, with or without appointment of a provisional administrator, setting up a provisional administration, withdrawal of the license and liquidation. Furthermore, the supervisory authority may, either in place of or in addition to these sanctions, impose a fine not exceeding the minimum capital of the covered entity. Article 53. The appointment of a provisional administrator or of a liquidator is an urgent administrative and protective measure. The covered entity concerned must be given notice of the measure, which is enforceable immediately. Article 54. The supervisory authority decides as a last resort jurisdiction in the case of the other disciplinary sanctions, which are of a moral or a financial nature. These decisions are enforceable immediately but may be appealed to the highest administrative jurisdiction on the grounds of legal flaw or irregularity.